I don't say that, but I just like, I gave them all day. The meeting of the Rent Control Board is hereby called back to order after its closed session. Please join me in a salute to our flag. Thank you. So we just reconvened after closed session. Would the general counsel mind giving us a report of closed session?
Yes, good evening, commissioners, and good evening, members of the public. The board convened into closed session at 6:03 p.m. and adjourned from closed session at 6:24 p.m. with no reportable action taken.
Thank you. Moving on to agenda item 5, may I have a motion to approve the minutes from our last meeting?
So moved.
Great. All those in favor?
Aye.
Aye.
Any opposed? No. I'll abstain as I was not here at our last meeting. Okay, moving on to special agenda items. Any brief announcements from our administrator, Ms. Condon?
Yes, good evening. I don't have any announcements this evening other than to say that the board's next 3 meetings, so the February, March, and April meetings, will be in the east wing of the Civic Auditorium. All of the meetings that are usually in the chambers are being moved for the next 3 months because the audio-video system is being upgraded. So that's where we'll be meeting for the next 3 months. Other than that, Happy New Year to all, and that's all I have this evening.
Thank you. Moving to public comment. This is the time set aside for any members of the public to address this board on items not directly on the agenda, but that are within our subject matter jurisdiction. Please note we cannot respond or take any sort of official action on items put forth for public comment. We have one speaker.
Chair, before we do that,
Yeah.
did the board want to approve the minutes of the last?
We just did that.
Oh, you did? Oh, I'm so sorry.
Yeah, we
Excuse
did
me,
that.
I missed it. Oh,
Yeah.
You're so efficient. I'm so sorry.
Moving on. But thank you. Sorry, so Ms. Golden-Gieler, Happy New Year. You have 3 minutes.
Sunday night. Did you watch 60 Minutes on Sunday night? Well, you should have. If you had watched it, you'd already know that 60 Minutes watches rent board meetings to get ideas for their shows. In fact, 60 Minutes agreed with my investigative reporting, which maintained there are 3 things that don't hang themselves. Number one is drywall. Number 2 are Christmas ornaments. Number 3, Jeffrey Epstein. Epstein didn't kill himself. Epstein didn't kill himself. I can't believe Epstein killed himself. But enough about Jeffrey Epstein. Do you ever wonder what owners think of rent board commissioners? Wonder no more. Owners think you see yourselves as rulers. Lonnie will now pass out rulers to those who see themselves as rulers. Lonnie?
Do you want to accept the...
They're beautiful rulers. They're plastic. They're very stylish. And they're safe.
You can leave them with Lonnie and we'll consider any written
Gee,
testimony.
Be
Thanks.
careful. They're dangerous. While Lonnie is passing out rulers, which I thought he would be able to do, to those who see themselves as rulers, here's another question. Do you ever wonder how owners see themselves? Owners definitely see themselves as stakeholders. Thank you and Happy New Year.
Happy New Year. Thank you very much. That is it for our public comment. Now we'll move on to jurisdictional items, which are our owner occupancy exemptions. Going first, I don't know if anyone wanted to. Yes, I see Commissioner Phyllis. Go ahead.
In light of the staff reports and the clarity of the recommendations, I realize that we have some speakers, but I would be inclined to move that we grant both item 10A1 and 10B1.
Can I ask a question?
Sorry.
Are any of the speakers anything other than the owners for whom the recommendation is already to grant?
We actually don't have any speakers on 10A1 or 10B1, unless I'm mistaken. I do not see them here in the public comment.
Yeah, and I think we should hear from staff on C1.
Right.
But this would just be 10A1 and 10B1.
Okay, so we have a motion to approve the staff report and
To
adopt.
adopt the findings of fact and conclusions of law and the recommendation to grant the owner occupancy exemption for 149 Fraser Avenue and 3002 Pearl Street.
Do I hear a second?
I will second, again, because the evidence is clear and the report makes it obvious to me.
Great. Can we get a roll call? Thank you.
Commissioner Sultan,
Yes.
Commissioner Phyllis,
Yes.
Commissioner Foster,
Yes.
Commissioner Duran,
Yes.
and Commissioner Trosis.
Yes.
Motion carries.
Okay, 10C1, we have an appeal on 917 21st Street, Unit E. May we please hear a staff report?
Good evening, Commissioners. James Harmon, Mariana Davanzo, and their 3 children rented Units D and E at 917 21st Street. Unit D is a 3-bedroom unit. Unit E is only a bedroom and a bathroom. It doesn't have a kitchen. Each is a separate unit with its own MAR. Each has its own lease. The current owners inherited the property from their parents. He and Mr. Scowron has petitioned the board to find that the Harmon Davanzo family no longer occupy Unit E as their principal residence. The eldest son, James, used to live in that unit until he moved away. Then their son, Stephen, moved into the unit until he moved away. And the family then sublet the unit until they were told that that violated their lease and had to stop, which they did. They were thinking of what to do with the unit and considered using the room as an office or a place for Mr. Harmon to teach music. When the landlord's manager visited the unit back in August of 2018, the unit was apparently empty of occupants. But then, apparently, Stephen, who attends graduate school at Bard College in New York, moved back into the unit as his bedroom, which is the only way the unit can be used, and which he uses when he's at home. Almost a year after they had inspected the unit, the landlords decided to file a petition with the board, claiming that the unit is only used as office or storage. Therefore, the tenancy of the unit should be treated as a tenancy not in occupancy, as under Regulation 3304, and that the board should reset the MAR for the unit based on recent market rents. However, the evidence in the record does not support the landlord's claim. When the investigator visited the property, she found that it was filled with Stephen's clothes and personal property, and Stephen was even there at home during a break. It is undisputed that Stephen spends much of the year away at graduate school, but it's also the case that Stephen has not set up his domicile in New York. Even the house that he has rented there is a furnished home near Bard, not an apartment for which he had to purchase his own furnishings. Board's regulation in this matter lists 9 factors to determine whether a tenancy of a unit is not in occupancy. The fact that a tenant is absent for an extended period of time is not sufficient to find the tenant to be not in occupancy, certain extended absences are specifically excused because they're considered as temporary. These include travel for educational purposes and academic sabbaticals, and the temporary absences don't need to be brief. Peace Corps and military service are two examples cited in the regulation as excused absences, and those last for years. The hearing officer therefore reasonably found that Stephen's extended absence at Bard did not result in his having given up Unit E as his principal residence. Other factors in the regulation also supported the hearing officer's conclusion. When at home, Stephen carries on his basic living activities in Unit E, except for those that he can't because of the unit's limitations, such as preparing meals, which he does in Unit D, his parents' unit. Stephen's clothing and personal effects are in the unit, another factor in the regulation. The unit is not used for office, entertainment, or storage, which is another factor in the regulation. But despite multiple factors supporting the conclusion that Stephen occupies Unit E as his principal residence, the hearing officer granted the landlord's petition. She did so because one of the factors listed in the regulation, which states that if a tenant rents more than one unit on the property, and there are an excess number of bedrooms to occupants, that can be considered as a factor supporting the landlord's petition. The hearing officer found that the tenants failed to provide evidence that showed their daughter Chelsea to still be residing in Unit D. Essentially, in Unit D. Essentially, she found that Chelsea had relocated to New York. So there was an excess number of bedrooms to occupants in the two units. But that is only one factor. The regulation does not state that this factor overrides all others or stands separate from the rest, or can be the sole basis for a decision on a petition for tenancy not in occupancy. The record is clear that Stephen does use Unit E as his principal residence along with Unit D because of the specific limitations of Unit E. If he did not actually use Unit E as his bedroom, then the excess number of bedrooms could serve as a dispositive factor. But that is not the case here, especially in a case when the hearing officer found that members of the Harmon family do in reality occupy both Unit D and Unit E as their residence. In the written response to staff's report, one of the co-owners, Susan Hightower, and her husband, Ross Hightower, also point to the fact that Unit E was previously sublet and not occupied by a family member when they inspected it 2 years ago. But the landlords did not file their petition then. They filed it a year later, by which time Stephen had moved back into Unit E as his bedroom, a finding of the hearing officer that the landlords never appealed, so it is a finding that is not before the board. Therefore, what happened in the past is immaterial to this appeal's outcome. Given this record and the finding of the hearing officer and the fact that multiple factors support the conclusion that members of the Harmon Davanzo family occupy both units as their principal residence, staff recommends that the board reverse the hearing officer's decision and deny the landlord's petition.
Okay, we have comments from the appellant. 5 minutes. Sonia Beckoff. I'm so sorry, Mulho. You have 5 minutes.
Thank you. Sonia Beckoff, Mulho. Obviously, we're very happy with the staff opinion on appeal. I'd like to make a couple of comments, though. The scope of a hearing is normally set out by what's in the pleadings. In court, we have complaints, petitions. In Rent Control Board, we have a petition. And the petition here, and I'll read it, it's short. Unit E is being used for storage and leisurely activities, while Unit E sits vacant. Other citizens are losing out on a potential housing opportunity. Unit E is not occupied for extended periods of time. This resident lives full-time in apartment D, which has 2 bedrooms and a den. Quote, unquote. That is the entire scope of the petition. Nothing about where Chelsea lives, whether she does or doesn't reside full-time, part-time, or any other period of time in apartment D. So we were blindsided by the decision from the hearing examiner. Most of it we were happy with. Finding of fact 29 we were happy with. It specifically states that Stephen uses Unit E as his bedroom when not in school. Finding of fact 39 is fine. That found that Stephen's absences fall within Regulation 3304 sub G sub 7 because it's an absence due to school. But findings of fact 47, 48, 49, and 52, wherein the hearing examiner complained that we didn't put on sufficient evidence about Chelsea's whereabouts, are not within the scope of the hearing. And we were given no indication that the hearing examiner wanted information on that. So for that reason, as well as for the reasons enunciated in the staff opinion on appeal and stated verbally tonight, I ask that the hearing examiner's decision be reversed. If for any reason the board is not comfortable simply reversing it, then I would ask that you send the matter back to the hearing examiner for further evidence, and we will put on evidence about Chelsea's whereabouts. I'd like to reserve some time for rebuttal, if I may.
Thank you very much. We have Ross Hightower. You have 3 minutes. And then just to be clear, Susan Hightower has 3 minutes after Ross Hightower, and then Daniel Sloan has requested 3 minutes.
Good evening. My name is Ross Hightower, and my wife and her siblings did inherit the property from their parents. I'm just curious as to what bearing, why that was even brought up. I just don't understand why that matters. However, moving on, I will say that the hearing officer heard about 2.5 hours of testimony. She was able to ask us questions and to parse the credibility that she was given and then make a decision after a pretty considerable amount of time. And I think I agree with tenant council that we feel blindsided too. And the reason we feel blindsided is in the hearing, 2/3 of the speech was given by the tenants and their counsel, and then when we tried to speak or ask questions, we were told that we had to whisper them to our property manager. We couldn't directly talk. So that really shut down the process. And the other part that we felt blindsided by was when we got the hearing officer's decision in our favor, we thought great, and it said you have 10 days to appeal. We didn't want to appeal that decision, but now what we're finding out is that there's a process aspect here that because we didn't appeal anything in it that we didn't agree with, that we have no right to discuss it now. And that wasn't explained to us. So it just doesn't feel very fair. And I would agree that, well, first of all, it's a stretch to say that it's like a game. So it's like the whack-a-mole with the short-term tendencies. You get somebody, they get them out and whatever, and then they do it all over again. Well, we accidentally found there was a tenant in there, and we come to find out there's been years of this going on, and then we inspect after they moved out, and then in August of 2018, and then in March of 2019, did again, completely empty, no personal items. A petition's filed, voila, we've got a whole bunch of personal items in there. Well, you know, we can play that game, but really the question too is, why didn't Stephen testify? He was there at the time of the inspection. The tenants chose the date for the hearing. They could have had him there. So to take as gospel that he's there without having a chance to question him about his residency and where he's living back east, because if you look him up on his website, he lists himself as receiving his master's in 2019 at UCLA. So there's just a lot of things that really stretch one's imagination to believe this. But I would agree with the tenant council that I really think, if anything, if you can't uphold the hearing officer's decision, which I really think you should, then you should remand it back to the hearing officer, and we should do this again. Yes, of course.
maybe it's a question for you, but also just in general. Was any of this evidence that you're referring to right now in terms of the different uses for this unit in question proffered during the hearing?
It was admitted to by the tenants that they.
Do we have pictures of the different uses of the units, including it not
It was
being?
just vacant. It was just nothing there.
Do you have pictures of that? Yeah, is it part of the okay? Okay, that's it for right now. Thanks. So, Susan Hightower, you have 3 minutes. Yeah, I don't know. I'm actually, let me just point of clarification. How many minutes are they permitted if they're both representing? Yeah.
I think that the way that the board should do it is that each side gets the number of minutes, but
Is this a witness, though?
But in recent hearings, the board has given the number of hearings allotted to a side to each person on that side who wants to speak. But that's what the board has decided to do recently. It's up to the board, but I think that the appropriate thing to do is to give the allotted number of minutes to each side.
Okay, so Ms. Hightower, are you representing your position, or are you here as being called as a yeah, are you being? Yeah, she is a party, but I'm just checking. I guess it's
I don't get
the petitioner.
5 minutes.
Who's David?
Her brother.
Okay, is her brother here?
No, he had to be out of the country, out of the state.
So you're representing the family.
I am the family.
Okay, so 2 more minutes then. Okay, you have 2 minutes.
I am part owner of, I mean, how many minutes?
2 minutes.
Okay, my husband said most of it. I think there were a lot of discrepancies at that original hearing, me not being able to refute any of the information, and then finding out through this paperwork that we should have appealed parts of the appeal. I think that was badly written. I would have appealed many of that. I would have done it in the hearing. I would have done it written afterwards. Just on that note. There's definite proof that the tenant sublet the property for many years, which was not allowed in his lease. It wasn't till we found out and gave notice, and a year later when we filed the 3304, that that all of a sudden their son Stephen was returning there. So I don't really understand. I feel like there's 4 bedrooms total. Maybe there's 3 people there. Also, I know there was something made to the fact of the 9 factors, but it also said that you could, it wasn't limited to 9 factors. So I do think the subletting needs to be one of those factors that come into play when you do make your decision. The hearing officer, I felt like she did take a lot of time to come up with her decision. I hope you do respect that, even though I felt at that hearing that I was not allowed to refute. And now it's being called what is the word that was in there? Sorry, not coming up with it now. That's it.
I just want to make sure that I'm understanding. So when you say the unit was sublet for years, was that Unit E?
Unit E was sublet for many years by many different people.
And what was the time period when it was sublet?
We don't really know. We didn't discover it till by accident when we met one of the subtenants.
Okay, and when did you discover it?
It was, I believe, March of 2018.
Okay.
It was 2017. Sorry, I have
July.
to
So between July 2017 and March 2018, around then, so between then.
The tenant, Mr. Harmon, begged us to let his sublease person stay there. We knew that wouldn't be a good precedent to let them stay, so we did serve him a notice to perform or quit.
Okay. Was there any reason why you did not file a tenant not in occupancy petition at that time?
We were in the middle of changing our property manager. We fired one, we got another. I kept asking them, and I really didn't know about it.
Okay.
And it was only because of reading up on some things, because of finding out about the subtenancy, that I discovered the 3304. I never knew about it ahead of time.
Okay. I have a question for staff. What is the what significance and what weight can we give to the fact that this unit at least seems, based on it, it doesn't seem disputed, right? So it's undisputed that there was a significant period of subletting. What weight can we give to that? I think that's all I have. The only questions that I have, but
All right, I have a question.
can Stephen answer and then?
It was sort of, the answer to this question was alluded to, but not really talked about it in great detail in the supplemental staff report. Certainly the hearing examiner or the board on appeal could, the question again is what is the unit used for? Is this tenant currently in occupancy or not in occupancy? And the hearing examiner could have said, well, this unit has been sublet for years and years, and so I just don't believe, on the view, given that there has been all the subletting in the past, the hearing examiner could have said, I don't believe that this person is living there now, and I think that this is just a setup thing to make it look that way. The hearing examiner, however, did not do that. The hearing examiner determined that whatever may have been going on in the past, Stephen really does live there now. That was the finding of fact. That finding of fact has not been challenged, and is not in front of the board because it hasn't been challenged. If it had been challenged, just like then the question would be for the board: was the hearing examiner's decision reasonably supported by the evidence, or was it not? And I think that question could go either way.
Okay.
But the significance of it is only as to the correctness of the conclusion that Stephen or whoever, any family member, is or is not occupying that unit currently. The hearing examiner found that a family member is occupying the unit as a domicile, permanent residence currently.
Got it. Okay. Got it. Thank you.
Yeah, just to clarify, you're addressing item A in the supplemental staff report, and you're basically saying that it's immaterial because it's not for us before us on appeal, but it could be relevant should this be remanded. Yeah. Okay. Okay. Thanks. I have a question just to clarify, because I did think I read this, but I just want you to tell me, what's the situation in Unit E? Is there any sort of kitchen or place where someone who was subletting could prepare any sort of meals, refrigerate food, etc.?
Or, you could put a little refrigerator in, but there is no kitchen.
There's no kitchen. Is there a refrigerator in there?
No, I have
Not
no
that you
idea.
provided? Okay.
No.
All right. Thanks. Do we have any further questions? Okay. No further questions. And then I also believe that we have Daniel Sloan, who is here on 10C. Who is Daniel Sloan? Are you a lawyer?
He's our property manager.
Oh, the property manager. So we've already heard 5 minutes from them. So
He's a witness.
He did come all the way down here.
do we want to hear a witness?
I'll hear from him.
Okay.
He took a lot of time to come
Yep.
down. Thank
We'll
you.
hear from him.
Will I be able to rebut too, or not?
No, you guys have exhausted your 5 minutes. Mr. Sloan, you have 3 minutes. Unless you wanted to reserve any of that time and give it to another member of any party here.
I'm the last one. I'm the last one. Good evening. I'm Daniel. Oh, sorry. My name is Daniel Sloan. I'm with Howard Management Group. I'm the property manager for the property we're discussing tonight. I began management services on the property in February of 2018, shortly after I was hired on. I was informed of some tenancy issues going on in apartment D and E of this property. After a few notices and inspections, my office filed the tenant not in occupancy petition based on the understanding and confirmation that this unit was not being occupied by the current tenants listed in apartment D and E. I'm here to express my support for the original determination by the hearing officer. I want to reiterate that all parties had ample time to prepare and bring in witnesses for the hearing. The residents in question decided not to bring in the two proposed occupants that are supposedly living there on a temporary basis, and I've not seen or heard from anybody from the opposition since the hearing or before. So I want to express to the board that the original hearing officer and her decision should be supported, and I hope that the Rent Control Board will support us in providing housing to the public as it was originally intended. Thank you.
Thank you. We have a question from Commissioner Duran. Go ahead.
I just a quick question. Were you at the hearing when it took place?
Yes.
Okay. And do you know whether, in this case, the appellants had requested that either Stephen or Chelsea speak at the hearing at the time? I know you mentioned that the tenants didn't, but I'm wondering if you know whether in this case, the appellants had.
The question was, did the appellants have enough time to?
No.
Oh, sorry.
No, the question was, did the appellants request to get testimony evidence from either Stephen or Chelsea?
No.
Okay. No. That's the only question I have. Thank you.
Sure.
Thank you, Mr. Sloan. I believe that Ms. Mulho had reserved some time. Lonnie, do we know how much time she had? 2 minutes and 33 seconds. All right. Oh, go ahead, Nicole.
So I think it might be helpful for rebuttal if, and I don't want to cut into Ms. Mulho's time, but I do have a question, and I think sometimes that can be helpful for a
Okay,
lawyer.
so let's go ahead with the question before we formally commence the rebuttal time.
If you want to cover it. So one thing that I'm really struggling with is the significance of the prior subletting, and
Yes.
In particular, I would like to know. Obviously, I think as a body, we prefer to hear things on the merits, and it seems to me that the property owners did not quite understand their obligations on appeal. What is your? I think the most compelling argument for remand is addressing this subletting issue. I would like to hear from you why you don't think this case should be remanded.
All right. The subletting issue is really.
Are we starting the time? Or we have.
It's a red flag, actually.
Wait, hold on.
Sorry.
So I personally believe that it would be best if we gave her the full rebuttal time. Otherwise, we could have a 20-minute rebuttal based on questions here. So why doesn't Anastasia ask her question as well?
Could I answer this question first, and then I'm
Shouldn't
happy
this
to
be part
answer
of
any
her-
other questions. The subletting issue is a red flag for this reason. Yes, my clients did sublet in the past. They got a 3-day notice to perform or quit. They performed. They stopped subletting. My recollection of the testimony at the hearing, because we went into this in great detail, was that the subletting had stopped at least a year before the 3304 petition was filed. And the question in a 3304 petition is, what is the situation at the time the petition's filed? And the reason that Stephen did not testify, he was back in school. He was here at the time of the inspection of the unit by the investigator. and she so commented. Chelsea was also back in school. And as I mentioned earlier, we were never put on notice that there was any issue about Chelsea's residency.
But I don't know if that answers my question. Sorry, go ahead, Commissioner Foster.
So I just have two quick questions. So you sort of addressed it already, but I was going to ask about Measure RR in Santa Monica, for instance, gives people a corrective period if they are doing something that violates their lease or that violates some other Santa Monica law, and they're given notice to correct the behavior, and they do correct the behavior in a prescribed time, then the UD is not to be brought or not to be enforced, correct?
There was never an unlawful detainer brought on the subletting issue.
Right.
I'm sorry.
But even if there were, there's a corrective period.
Well, Measure RR, which may have come into being after the performer quit notice. I'm sorry, I don't really recall.
2010, actually.
Okay. Then I don't recall that there was a Measure RR letter, the pre-notice warning letter that's required under 1806B, I think it is, of the Charter Amendment.
That answers my question.
Yeah.
And my second question is, if someone had a son or a daughter who served in Iraq or Afghanistan for 3 years, would they potentially Airbnb or sublet that bedroom until that son or daughter came back? Could college be sort of construed the same way? Whether or not they knew it was legal to do so within their lease or not, is it possible that that they were subletting while the children were away for college?
I think there are two questions there. And if somebody is away in Iraq, Afghanistan, or any place else for 3 years in the military, that unit is still, the tenant's still in occupancy because that remains the tenant's place of return when the tenant finishes his or her military career.
Was Stephen in the military?
No, he's a student. But I don't think you can Airbnb the unit while
No,
your
a bedroom.
child-
A bedroom.
I don't think you can Airbnb the bedroom. And here, Unit E is a bedroom and a bathroom. And so when I say the unit, it's basically the bedroom. I don't think you can Airbnb the unit while the child is either in school or in the military and still claim to be a tenant in occupancy. But we don't have that situation here. My client stopped subletting after they got the performer quit notice, and they haven't sublet since. And the hearing examiner so found.
I have a question though. I understand that you're saying that what the unit is presently being used for is what's at issue here, and any sort of past usage is not relevant. But and of course we can't hope to surmise what would have happened. But it sounds like there's no dispute that the unit was being subletted, and there's no dispute that they were told to stop subletting. So we don't know what would or could have happened had they not been found out. And additionally, is it your assertion that the only reason that the unit was being sublet is because there was an intent to return while their son was in school? Like, are you asserting that the subleasing was only for the period of time at which he was in school and that there was an intent to return at that after that point? Because I still haven't seen any sort of evidence during the period of some sort of intent to return. I know that that's not, we're not deciding this on the merits, obviously, but I'm just still a little bit confused about why past usage is not relevant here.
I don't know the answer to the question about whether the subletting was until Stephen was going to return. We didn't put on evidence of that because it wasn't brought up.
Right.
The way it was framed and the way the evidence was presented was, yes, there was subletting in the past, there was a performer quit notice, there was no further subletting. And at that point, regardless of what was going on while it was being sublet, at that point, Stephen started using it as his bedroom and was using it for, I believe, at least a year prior to the time that the petition was filed in this case. And so the subletting in the past does not matter because it's not the situation at the time of filing of the tenant not in occupancy petition. It might be different had the subletting occurred maybe 2 weeks before the petition was filed, and then it might look like we were trying to stage something on my client's behalf, but that's not the case here. And the hearing examiner was quite clear about that. The investigator found that Stephen was in occupancy and was actually physically present at the time because it was during a break in the school year, apparently. But he went back to school. He comes back when he's not in school. So the subletting is a thing in the past, and it doesn't count at this time. There was no staging here. Stephen was legitimately in occupancy of this unit and is only gone to go to school.
So I have a question for staff. If a family member of an original tenancy is domiciled, obviously, in that residence for their childhood, goes somewhere else for years, establishes a domicile somewhere else, and then returns to the tenancy and reestablishes the domicile with the original family, is that tenant still entitled to the fully controlled rates under a rent control ordinance? Does the break in the domicile change that tenant's rights to have a controlled rent?
Because of Costa-Hawkins, the answer is no. Because assuming that the other people who remain there continuously ceased to be there, and that's because Costa-Hawkins says that a landlord has the right to establish a new initial rent when the original tenants no longer permanently reside there. And although I'm not aware of any case that specifically that's gone to the Court of Appeal on this issue, the view that various trial courts have taken and that I think that we have taken in determining whether what we would enforce or not has been that if somebody leaves and then comes back after a period when they've lived somewhere else,
right,
and then the people who remained left, that they are not that they're not the original occupants because they started a new tenancy. But that's not something that is clear in the law. It's never, there's no Court of Appeal opinion about it. And so I can't really say definitively what the answer to the question is.
And I think it's difficult here for two reasons. One, the original family is still there, but two, this is a separate unit. Mm-hmm. And what I'm really struggling with is the fact, and I'm not sure if you were paraphrasing or if you were directly quoting from transcripts from what happened, but the idea that the family held on to this unit to try to figure out what to do with it is concerning to me because it suggests to me that that unit is not someone's domicile. If you don't know what you're going to do with it, I think there are serious questions about whether it continues to be the place of intended return for the tenant. So I am struggling a bit with that. I find the staff report persuasive, but I am concerned about the impact of, as it sounds like my fellow commissioners are,
So-
the subletting.
So just a procedural point here. It sounds like we have Commissioner Foster wanting to say something. Do you have a question for Ms.
No,
Mulho?
I want.
Okay, so should we continue this line of questioning after we let her finish her rebuttal? I think that would be procedurally appropriate. So why don't we give her the 2 minutes, 30 seconds to do that and have her sit down? Thanks.
Thank you. Could I perhaps add to what Mr. Lewis said? Under Costa-Hawkins, if you have 4 people occupying a unit and one of them takes off for a while, but the other 3 continue to reside there, and then the one who's been gone for, let's say, 2 or 3 years comes back, you're not going to have a situation where the landlord can raise the rent because 3 of the 4 original occupants are still in occupancy. But 3304 is somewhat different than Costa-Hawkins. What I wanted to say in rebuttal was at the hearings, Mr. Sloan was appointed apparently by the Hightowers to speak for them. They chose not to bring counsel or a paralegal, and as a property manager, he acted in place of counsel or a paralegal. And so the complaints that I thought I was hearing this evening from Mr. Hightower that he didn't get to speak, he spoke through his counsel, Mr. Sloan, who acted as counsel, who asked questions and pretty much functioned in the same way that I functioned for my clients. Mr. Sloan is not an attorney, so he had a bit more problem proceeding, but that's the way they chose to do it. The rest of what I thought I was hearing from the Hightowers is basically trying to rehash the evidence on points they didn't appeal and that therefore are final. The only issue before the board was the hearing examiner's decision legally correct, complaining about the evidence we didn't put on about Chelsea's whereabouts when that was never the subject of the petition. And on that issue, I submit the staff report on appeal is correct, and I request that the board follow it. Thank you.
Thank you very much. We will now move to questions and comments from our commissioners. Commissioner Foster, you were next.
Yeah, I've got a couple of things. So, Stephen, first of all, when you were answering Commissioner Phyllis's question a moment ago, her example, I can't speak for her as to what was in her mind when she asked it, but her example presumed that somebody moved away and established a new tenancy somewhere else. But isn't it true that in our record, Stephen never established another domicile? He rented a furnished place while at college? Because in her question, I didn't hear in your reply the note that was in the record.
The family rented both of these units, although they're two separate. I hesitate in some ways to call them both units because one is not a lawful unit, but they're registered with us
that's in my file,
as two units.
Stephen in New York did not establish another domicile.
Right. The finding that the hearing examiner made, and that has not been disputed in the hearing, is that on appeal, is that the members who are claimed to be there now have never lived elsewhere. That the mother and father and Stephen have both continuously had as their domicile units D and E. Units, the parents have always fully occupied unit D. I'm sorry. Unit E was first occupied by one of the sons, and then by no family member, and then currently by the son. What was rented what was rented was this conglomerate of places as the family home.
Right. So I wanted to ask about that next.
And in some ways,
you read my mind.
In some ways, it's no different than if they had rented a 4-bedroom place and somebody and they were illegally or in violation of their lease renting out a bedroom in their place. That may have been a basis for eviction, and if they were given a notice to quit, they'd have to stop quitting it. So as the family rented it and as they used it, this was all one place, even though it is registered with us.
Right, because the original landlord in the testimony, the original landlord said, I will only rent this as a group, a pair of units together to one unit of family. Also, I wondered, Exhibit 22 is not actually attached. Exhibit 22 is a 1994 finding by this body and this agency concerning the fact that the bedroom is basically an extension of the original apartment. It's not really a separate unit. It has no kitchen. And also minor children were sleeping in this Unit E most of their lives, because when they moved in, they were ages 7, 5, and 2. So it's really, in my perception, it's not reflected in the current staff report, but in diving deeper back into the record, the original landlord intended for this to be a bedroom extension of Unit D, but for some reason in 1994 was classified as a separate unit. If a minor child is able to sleep in it, it's not a separate apartment. It's just a bedroom addendum because of the strange construction over
is
the
that
garage units. That's
how relevant
I'm asking,
is that?
Well,
How
I think it's
relevant?
incredibly relevant.
Legally speaking, how relevant is that to you?
Commissioner, I do not believe that in that decision to which you referred that there was a finding that the minor child was sleeping in the Unit E.
Right. I mixed my presumptions with the ages the children were when they moved in, but the fact that the landlord said these are only to be rented together and that it's not a legal unit, it doesn't have a kitchen. So I'm wondering why it was ever called Unit E as a result of some board action in 1994.
I don't really know. But to complete the thought that I was beginning earlier, the only basis, the hearing examiner took the evidence from the parties as to how the units are used. There was a lot of testimony about that from the parties. It wasn't as though that was glossed over. The parties hotly contested.
That's in the...
How was this used? And after hearing from the parties, the hearing examiner said, okay, well, Stephen does have, he lives in DE, but the place that he actually has as his room is E, and the place that the parents have as their room is in unit D. Thank you. So those were the factual findings that the hearing examiner made. The only basis for the hearing examiner's determination that there was a basis on which to increase the rent is that there were fewer bedrooms than there were persons in the combination of the two units. So the difficulty is with the board taking issue. I mean, how the board proceeds with this is up to the board, but the procedural difficulty is how can the board approach challenging a factual finding that was litigated by the parties and made by the hearing examiner that wasn't challenged on appeal. That's really the.
Do you think we have any basis for remand?
That's really up to the board.
Sorry. So what is the legal standard for remand? Because it would.
I'm sorry. I understand.
Yeah.
If the board believes that the party that there was an issue that was not fully developed, that the parties didn't really litigate, that's critical to the outcome, then that would be a basis for remanding it.
So if we find that the subletting issue, which the staff report has advised, because of the way that because of the failure of the property owners to appeal, that's not before this body. But if we find that wasn't properly developed or addressed before the hearing examiner, that would be a basis for remand. Is that right?
It would be.
Okay.
Commissioner Foster, are you done with your comment?
Would it be back to the same? I'm just curious for process. We haven't often done this. Would it be remanded back to the same hearing officer, or would it be de novo? Would they start from scratch?
Okay. I'm not really sure how the assignment of cases goes. Ms. Nalovoff can probably answer that question better than I can.
Uh-oh.
Not on.
Not on.
It's like ghost mics tonight.
There you go.
Okay, thanks. In general, when cases are remanded, they go back to the same hearing officer and they only develop the evidence that the board specifically asks for, rather than starting over with the entire case.
Thank you.
From scratch.
So if we were to remand, and Stephen just indicated that they did discuss quite thoroughly the issue of sublet. So if we say go back and talk about sublet more, will they?
Actually, Stephen, I'm a little bit. When you said that it could go either way, but this wasn't developed on appeal, were you saying? Sorry, you said before when I said, what is the significance of the subletting? Does it cut off his domicile? Does the fact that he reestablished it, is that material? That fact, it sounds like, was not fully addressed in the hearing. Would you agree?
I don't think I would agree.
Okay.
What I was saying before was that I could imagine, if I were the hearing examiner, for example, hearing all the testimony, I could imagine myself as the hearing examiner thinking, well, there is a question.
Okay.
Does this person really live there, or was this some sort of setup situation?
Right.
And I wouldn't fail to at least have the question occur to me because of the long period of subletting. it appears that this question did occur to the hearing examiner because there was this long discussion in the
Right.
decision about the fact that it was sublet and what does it mean and blah, blah, blah.
Right.
And so the parties litigated it, and the hearing examiner made a finding about whether the person is domiciled there currently, notwithstanding the fact that there was a period during which the unit was sublet.
Do you think that there are any issues, and I just want to make sure, do you think that there are any issues that were not properly developed that would justify remand? Because if I missed this in the staff report, I'm sorry, but I didn't see a whole lot of talk about remand.
Yeah, we didn't talk about remand because it appears as though everything was fully litigated. And the only issue on appeal really is the legal issue of does the fact that all by itself, does the fact that there are fewer people there than the number of bedrooms necessitate the result that the hearing examiner reached. As Ms. Mojo pointed out, the whole basis for the filing in the first place was he's not really there, nobody's really there living there, and that's what they litigated.
Right.
They didn't litigate the issue of what does it mean that there are fewer people than there are bedrooms. They really focused on is this really being used as a part of this family's residence or not. So that was the subject that was litigated, and the hearing examiner made a finding on that. But then found yes, in fact, both parts of this property are being used for the family residence. But there's this other issue of the fact that there are a smaller number of bedrooms than there are of people.
There are a smaller number of people than
I'm sorry.
bedrooms.
Yes, thank you.
Okay.
Sorry, moving on. Commissioner Duran has been patiently waiting.
Oh, sorry.
That's okay. Okay, so I'm hoping to clear this up a bit. It seems to me that and we've talked about it now. The only issue here is whether Stephen was domiciled or or not. And I think that the issue as to what happened with the daughter, I'm sorry, I forgot her name, Chelsea, in Unit D is a completely separate issue. One that should the owners decide to bring that issue up separately, they're certainly entitled to do, but that's not what, I think it was error for the hearing officer to bring that into play into the decision that they made regarding the issue before us, which is whether Stephen was domiciled in Unit E or not. And the evidence that we have, which was uncontested, was after much debate between the parties, apparently, it was determined that Stephen was in occupancy at the time. Be it that he goes to Ware College or is in the military or whatever it is, the fact is that he went away to college. And based on my own experience, I went away to college, but I still expected to have my bedroom at my parents' house in the summer and after I graduated. And I don't see why Stephen, in the case where he goes to school in New York or wherever else, wouldn't have that same expectation. More importantly, the evidence showed that there was evidence that it remained his occupancy. There were belongings there that would indicate such. Also, in regard to what happened in the past with the subletting, if that went on, which apparently it did, it's irrelevant because they quit. They were told they got to stop doing it, and they did. And that was, as far as I tallied up the years, it was at least a year before this issue was even raised. So why that's having carrying such heavy weight in the decision before us, I'm not sure. There was uncontested evidence that Stephen was in occupancy. That was the reason for the complaint or the petition that was filed. That was the reason for the hearing took place. That's the reason for the appeal, and that's the issue that we're here to decide today, only. So, and in relation to that, did the hearing officer commit legal error, I'm losing my words, in making the decision that the hearing officer came up with, and in raising the issue with Chelsea's domicile, I think was clearly erroneous and shouldn't be part of the decision here, which is why I feel that the only move in this case would be to reverse the decision of the hearing officer. Anyway, those are my 2 points. I hope that clears it up for some. That's my opinion.
Thanks. Commissioner Sultan?
So one question I might have, were we to remand? And I definitely see the perspective that the hearing officer erred by focusing on the number of bedrooms, particularly who's living in Unit D as opposed to Unit E, which is really the unit issue. Is how long can someone maintain that their domicile is in Santa Monica but actually not full-time live here? Like, how long could that go on for, right? We've said it can go on for a number of years if somebody's in the military for 4 years, if somebody's in school. In this case, we clearly have a young man who's believes in education, and I think he's on his second graduate degree. He's not lived here for at least 6 years, and I think he's not actually been a full-time resident of Santa Monica for 6 years. I think his current graduate degree program terminates in 2022, by which time he won't have lived here full-time for 9 years, I think. So I do wonder if there's an end point at which it, no longer, somebody would no longer deserve the protections or be entitled to the protections of Santa Monica's rent control law when they don't live here full time.
Just for the sake of clarity, I want to be clear that under no circumstance would the board's decision deprive somebody of the protections of the rent control law. The unit would still be subject to rent control, but the rent would go up.
Right. Excuse me. Okay. I was misspoke.
Thank you. Hold on. Before I go to Commissioner Foster, I'm just going to take a point of personal privilege and jump in here because I haven't had the opportunity to comment. For me, after hearing all the evidence, what was in the record and what we've heard tonight here, and the non-persuasive arguments, as far as I'm concerned, that I've heard from our landlord, although understanding where they're coming from, yet the points being made not necessarily relevant legally speaking here. I'm prepared to move this item. I don't know if that is helpful for anyone here. Okay. Yeah. Did you want to make it? Okay. Sure. Sure. So I move to affirm the staff report and reverse the hearing officer's decision.
Second.
Okay. Can we call for a vote, please?
Yeah.
Sorry, modifying the.
Yeah, with these things where they're
Yep, sorry.
Oh, yeah.
Thank you. I agree with that. I modify the following paragraphs 53 and 54 through 65. Modifying the following paragraphs and findings of fact and conclusions of law, and on the decision, adopting those recommendations as well.
You're seconding it?
Yes.
All right. And ready for a vote?
Yes.
Commissioner Phyllis?
Yes.
Commissioner Duran?
Yes.
Commissioner Foster?
Yes.
Commissioner Sultan?
Yes.
And Commissioner Trosis?
Yes.
Motion carries.
Okay. Moving on to item 12A, considering amendments to our regulations. Mr. Lewis, can we please have a staff report?
Our regulations require owners to register their ownership of each rent control property, and they also require owners to register new tenancies under a variety of circumstances. And they allow tenants to apply under certain circumstances to withhold the entirety of their rent for as long as those registration requirements are not complied with. The board authorized the modernization of our database, and that's now in process. And as a part of that process, staff has examined every type of information that goes into the database. One goal of the database modernization is to enable owners to engage in a certain amount of self-service by, for example, self-filing or electronically filing registration forms and other things like registration forms online. Staff's examination of both the substantive and procedural aspects of registration form filing has resulted in our realizing that if regulations remain as they currently are, the goal of allowing owners to self-file registration forms will be frustrated. For example, current regulations require owners to provide ownership information on individual unit registration forms, but owners are already required to provide that when they register their ownership or register a change of ownership. So requiring them to provide it with each registration of each unit needlessly requires them to provide duplicative information. And if there's any error on the statement of the owner name, the computerized system will not allow the unit the unit's tenancy to be registered. And as a result of that, the registration won't occur. In our experience, there are often small, non-substantive errors in the ownership portion of an individual unit registration form. And it makes little sense to create a system that includes a high likelihood of significant number of registration forms not being efficiently filed online due to a problem on the form with information that we have no need for purposes of that form to collect. And it certainly makes no sense to create an expectation for tenants that they might qualify for rent withholding due to a technical form filing error that bears no relationship to the reason for which we collect the information on the form. Proposed amendments to regulations 3301, 8010, and 13002 would fix this problem by eliminating the requirement to needlessly provide duplicative ownership information and also eliminate tenants' ability to apply for rent withholding due to an owner's failure to provide it. Staff is also proposing amendments to Regulation 13001 to require an owner that is a trust to include on an ownership registration the names and street addresses of all trustees, and require that owners who wish to receive electronic communication from the board provide us with a working email address. Finally, staff is proposing additional amendments to Regulation 13002 to require that any person filing any type of registration form include contact information form on the basis of which we can contact them. That's it. Thank you.
Thank you.
Sorry, this thing keeps falling off. Commissioner Phyllis. Go ahead.
So I think this is straightforward, makes sense, good process. Holy
Go ahead. Go ahead. Not appropriate.
And so I would move that we adopt the proposed amendments to regulations 3301, 8010, 13001, and 13002 as set forth in the report.
Second.
I actually want to make a comment before we do that.
Yeah, there's no one.
No one has requested to speak. It is a public hearing. I have some questions, as usual. So it would be helpful if in the future, I anticipate that maybe you came to us because this is the only thing that needs to be changed as a result of the rent registry, the new rent database system that we're putting together. I don't know if it's readily available, and I understand that we're probably coming up with like a process map and like which process flows we're automating and how we're doing that and all of that. But it would have been helpful if we could have seen some of like the draft forms of what's changing from this to that going forward. Like I'm a visual person. I'm just giving feedback that to me it would be helpful to see the practical implications, because it seems like there are pretty readily available practical implications of making these changes. And so it's just hard for me to visualize exactly what we're changing when I don't have it. Yeah, or just the form, or what we're having them fill out. I agree. I love that we're making them list the names and addresses of all the trustees.
Yes.
I'm going to be really annoying and ask something that you're probably going to say no to, but I understand that we're only asking people to give us their email address if they are wanting electronic communication. I personally think we should require their email address, and if they don't want to give it to us, they should be able to opt out. But I think that there needs to, right, yeah. I mean, just if I were thinking about this, I want to be going forward for the next, several years as efficient as possible, as cost effective as possible, and environmentally friendly as possible, and putting forward our communication. So I don't really want to give people an option unless there's some check box that they want to say that they don't want to give their email address. But I think we should have to require it. That's just my opinion. However, I know that won't change our regulations, so I just took this opportunity to say that because we had something about the email.
Are you in favor of the motion with providing that direction to
I'm in
staff?
favor of the motion providing that direction to staff. Thank you.
Can we call the vote? No.
We're going through, well, there are two things. One, this has been agendized, so that we can vote on this.
Right.
And we're going through this pretty painfully detailed process. We've heard that concern, and we won't forget it. It's also our expectation that owners will want to make things as easy as possible.
You would think so,
for
but
them.
if they don't have to be found, why would they give us our email address?
Yeah, but the point that I'm making is we've heard that we don't need a formal. This whole
You've received the direction.
Yes, exactly. We understand what you're saying,
right.
And the whole process that we're doing is geared toward making things as seamless as possible.
I know.
So
I'm just putting it on the record.
yeah, so we understand that, and I think there's widespread agreement that
Great.
we should.
And then, let's call the roll, and then I have one other thing to say.
Commissioner Drawn,
Yes.
Commissioner Sultan,
Yes.
Commissioner Phyllis,
Yes.
Commissioner Foster,
Yes.
and Commissioner Trosis.
Yes.
Motion carries.
Thanks. And then before moving on to the next item, just on this topic, I would like relatively soon some sort of formal presentation on progress to date. And I'm sure that that's in the works, but that's very important to me. Thank you. So I think we have our last item, which is the 12B, selection of chairperson and vice chairperson. I don't have like a formal,
The
Ms. Condon.
way this has been handled in the past is usually the board, anybody who's interested can make a nomination for the chair position. And if there's more than one nomination, then the board usually just takes a vote on, I choose A or B if there's multiple people until a chair is selected. And then the same process ensues for the election of the vice chair. So it's a fairly straightforward selection of a new chair and vice chair.
Correct, and I believe that we have our vice chair as Commissioner Phyllis, so I'd go ahead and nominate her to be the chair for next term. Yeah.
I accept the nomination, and I would just like to extend my personal thanks for Chair Trosis on a fantastic year. I think you've led with poise and tact and attention to detail that I think is an inspiration for us all. And I really appreciate the way that you bring your knowledge from your work at the county to the board. I think you're an incredible asset, and I am looking forward to supporting you this election year, and I think you've done a fantastic job, and I'm just very grateful to consider you my colleague. So thank you.
Well, that's overly kind. Thank you. Do we vote on the chair first, and then we'll go to the vice chair? Okay. All right. So was
Has there been a second?
the second?
I'll second.
Great.
Alrighty. Commissioner Foster,
Yes.
Commissioner Drawn,
Yes.
Commissioner Phyllis,
Yes.
Commissioner Sultan,
Yes.
Commissioner Trosis.
Yes.
Motion carries.
Congratulations.
Congrats. And then I would go ahead and I don't know if there was someone who wanted to be the vice chair, but I would say that Commissioner Sultan has not had that opportunity yet, and I think all of us have. So, just asking.
Yeah.
We hadn't talked about it, but putting that out there. What are your thoughts? You would have to chair the meeting if Commissioner Phyllis were not here.
Right.
And
Are you sure there's nobody else? I feel like I could use a little
Do it,
more
do it.
time.
It's
Do
yours
it.
to
Do it.
It's yours to defer.
Do it.
Yes. You should do it. He'll support you.
you're not.
Or
doing
one
it
more
until
year.
You do one more year. Nicole is the chair, and then you do it the year after that.
Right.
You could definitely do it.
Yeah.
Wait, I would do.
You're not the chair next
You'd
year.
be vice chair
No.
next
You'd
year.
be vice chair, and then it'd be one more year.
Yeah.
Can I keep Loki as my?
And you don't have to be the like. There
You
are
don't have to be the
people
chair if you don't want to
who
be.
have said they'll be vice chair, but who don't want to be chair.
We trust that you are up to the task.
Okay.
No pressure.
Yeah.
Okay, great. So I'm
Do it.
nominating you. Do I hear second?
Second.
I think. I
Then I.
think Commissioner Foster might have been
By a nose.
second ahead.
By a nose.
Great. So we'll call for a roll.
All right. Commissioner Phyllis.
Yes.
Commissioner Duran.
Yes.
Commissioner Foster.
Yes.
Commissioner Sultan.
Yes.
And Commissioner Trosis.
Yes.
Motion carries.
You can do it.
Congratulations.
Congratulations. I believe that those are all of our items for tonight. So do I hear a motion to adjourn?
Move to adjourn.
Great. All those in favor? Yeah, aye. Great. Thank you, and we are adjourned.
That's my phone. I was wondering.